Script, Antitrust Law, Business Law 1 Essentials. Did you know that in 1911, one single company controlled over 90% of all oil refining in the United States? That company was Standard Oil, and the government literally broke it into 34 separate companies just to restore fair competition. Today we're going to talk about the laws that made that possible and why they still matter every time you buy a product, download an app, or start a business. By the end of this video, you're going to understand what antitrust law actually is, why it exists, how the major federal laws work, what kinds of business behavior gets companies in serious legal trouble, and what happens when the government decides a company has grown too powerful. Whether you're a business student, an entrepreneur, or just someone who wants to understand how markets really work, this one's for you. Let's get into it. Section 1. What is antitrust law and why does it exist? Let's start with the basics. Antitrust law is a set of federal and state laws designed to promote fair competition in the marketplace and prevent monopolies. The word antitrust might sound old-fashioned, and honestly, it is. It comes from the late 1800s when giant corporations called trusts were taking over entire industries. Here's the core idea. In a healthy market, businesses compete with each other. That competition drives prices down, pushes quality up, and gives consumers real choices. But when one company, or a small group of companies, dominates an entire market, that competition disappears. Prices go up, innovation slows down, consumers lose, and smaller businesses can't survive. Antitrust law steps in to prevent that from happening. The government acts as a referee, making sure no single player rigs the game in their favor. Think of it this way. Imagine if every coffee shop in your city was secretly owned by the same person, and they all agreed to charge $10 for a cup of coffee. You'd have no real choice. That's exactly the kind of situation antitrust law is designed to stop. So who enforces these laws? Mainly two federal agencies, the Department of Justice and the Federal Trade Commission. Both have the power to investigate companies, file lawsuits, and block business deals they believe would harm competition. Now, here's something interesting. The laws that govern all of this are over 100 years old. So how exactly did they come about? That brings us to our next section. Section 2. The major antitrust laws. There are three major pieces of federal legislation you need to know. Each one was created at a different moment in history, and together they form the foundation of antitrust law in the United States. First, the Sherman Antitrust Act of 1890. This is the big one. It was the government's first serious attempt to fight monopolies, and it has two key parts. Section 1 prohibits contracts, combinations, or conspiracies that unreasonably restrain trade. Section 2 prohibits monopolization, meaning you can't use illegal tactics to gain or maintain a monopoly. Violations of the Sherman Act can result in criminal penalties, including fines and even prison time for individuals involved. Second, the Clayton Act of 1914. Congress passed this one because the Sherman Act was a bit vague. The Clayton Act got more specific. It targets practices like price discrimination, charging different customers different prices to harm competition, and exclusive dealing contracts. It also restricts mergers and acquisitions that would substantially reduce competition. This is the law that gets triggered when two massive companies try to merge, and the government says, not so fast. Third, the Federal Trade Commission Act of 1914. This one created the FTC itself, and broadly prohibits unfair methods of competition and deceptive practices. It gives the FTC wide authority to investigate and act against a huge range of anti-competitive behavior. Together, these three laws give the government powerful tools to protect competition. But knowing the laws is one thing. The real question is, what specific behaviors actually get businesses into trouble? That's up next. Section 3. Illegal business practices under antitrust law. This is where things get really practical. Let's talk about the types of conduct that antitrust law specifically targets. Price fixing is probably the most well-known violation. This is when competing companies agree, either openly or secretly, to set prices at a certain level instead of competing honestly. It doesn't matter if the fixed price is high or low. The agreement itself is illegal. Courts treat this as a per se violation, meaning it's automatically illegal with no exceptions. Next, there's market division. This happens when competitors agree to split up customers, territories, or products among themselves. Say Company A agrees to only sell in the eastern states, and Company B agrees to only sell in the western states. Now consumers in each region have no real competition. Also a per se violation. Then we have bid rigging. This is common in government contracting situations. Competing companies secretly agree on who will win a contract and at what price, taking turns winning bids, while the others submit artificially high fake bids. It's fraud, and it's a serious criminal offense. Group boycotts, also called concerted refusals to deal, happen when a group of businesses agree to stop doing business with a particular competitor or supplier to drive them out of the market. And finally, tying arrangements. This is when a seller forces a buyer to purchase one product as a condition of buying another. If you want product A, you have to buy product B too. When a dominant company does this, it can unfairly crush competition in the market for the second product. Each of these practices distorts the market and harms consumers. But what about when a single company just becomes extremely dominant on its own? That's a different but equally important question. Section 4. Monopolies and monopolization. Here's a distinction that surprises a lot of people. Having a monopoly is not automatically illegal. What's illegal is monopolization, using wrongful or exclusionary tactics to gain or maintain monopoly power. If your company just happens to be so innovative, so efficient, and so good that everyone chooses you over competitors, that's fine. That's the market rewarding excellence. But if you use predatory pricing to drive competitors out of business, or lock suppliers into exclusive contracts specifically to choke out rivals, or engage in other exclusionary conduct, now you've crossed the legal line. Courts typically look at two things. First, does the company have monopoly power, meaning the ability to control prices or exclude competition in a relevant market? Second, did the company acquire or maintain that power through anti-competitive conduct rather than legitimate business achievement? This is exactly why companies like Microsoft, Google, and Amazon have all faced antitrust scrutiny. They're dominant. The question regulators ask is, how did they get there? And are they using that dominance unfairly? Section 5. Mergers and antitrust review. Every time two major companies want to merge, the government takes a hard look. Why? Because mergers can dramatically reduce competition overnight. Under the Clayton Act, mergers that would substantially lessen competition are prohibited. The FTC and the Department of Justice review major mergers before they happen. Companies above a certain size are required to notify the government and wait for approval under what's called the Hart-Scott-Rodino Act. Regulators analyze things like, how much market share would the combined company control? Are there still strong competitors left? Could new businesses realistically enter the market? Would consumers actually be harmed? Sometimes the government blocks a merger entirely. Sometimes it approves the merger but requires the companies to sell off certain parts of their business first, called divestitures, to preserve competition. So let's bring it all together. Antitrust law exists to protect competition, which ultimately protects consumers and keeps markets healthy. The Sherman Act, the Clayton Act, and the FTC Act are the three pillars of this legal framework. Price fixing, market division, bid rigging, and monopolization are among the most serious violations. And every major merger gets government scrutiny to make sure the market stays fair. These laws affect every industry, from tech to healthcare to retail. And in an economy where a handful of companies are growing more powerful than ever, understanding antitrust law has never been more relevant. If this video helped you, hit that like button and subscribe so you don't miss the next chapter. Drop a question in the comments. Whether it's about a specific case, a concept you want clarified, or just something that surprised you today. I read every comment. See you in the next one.